Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. The law firm that I was with for the better part of the last 20 years handled one of the biggest class action lawsuits in history a few years ago against AT&T. It revolved around cell phones and fees and things that were charged inappropriately. In that lawsuit, we worked very hard to provide the benefit to class members, and we fought hard to ensure that those benefits were real. In other words, that somebody was going to get money in their pocket at the end of the day. And for those people who did not want to take part, we allowed them to opt out if they wanted. And we believed we were required to allow them to opt out. And we got, at the end of the day, about 6% of the actual settlement value as our fee, which was a fair amount considering the level of work that we put into that case. Now, class actions are really good things. While each claimant in that case only had a claim between $15 and $50, which even if they'd brought it in small claims court, they would likely not have been able to get made whole again. We were able to get them reimbursed and made whole. AT&T paid them, and the fees were paid by AT&T to us. It didn't come out of the money that the claimants got. I believed at the time, and I still believe, that it was an exceptional piece of legal work, and I was very proud to have had a very small hand in it. I've also been a class claimant in a lawsuit in federal court in Nevada. That was the infamous Sobel case against Hertz. I objected in that settlement because the settlement was a bad deal all the way around. The settlement provided a voucher for a free rental at some time in the future, so it made me deal with someone that had already defrauded me once, and the legal fees that were being paid and being deducted out of the settlement, out of a common fund, I thought they were outrageous. So I objected, and while I don't claim any personal credit for it, the court ultimately rejected that class action settlement, which was the appropriate thing for the court to do. So I put that in here by way of telling you that I know my way around class action lawsuits and class action claims, and more importantly, class action settlements. I've also been one of the people who did some of the work in a medical monitoring class action. And that brings me to the Phillips Settlement. So you get this nifty notice in your mailbox that says Phillips is putting $25 million in a settlement fund for medical monitoring, and you are in the class. Is this a good deal? Well, I want you to decide. First, what tangible benefit does this lawsuit produce for you? Now, according to the notice, you get medical advancement program benefits for 15 years. Wow, sounds like a pretty good deal. Yeah, maybe not. What are actually those benefits? Well, let's read them. Funding independent medical research, MAP research, which will contribute to the advancement of public knowledge and education with respect to the detection, diagnosis, and/or treatment of those injuries alleged to have been caused by use of the recalled devices. Interesting. I don't see any way that directly benefits somebody, because we don't have any idea what medical research is going to be done and whether it's going to contribute to the body of knowledge or not. So I don't see that as a huge benefit. Establishing a research registry for settlement class members to which they can elect to submit authorizations for the release and disclosure of medical information protected by HIPAA for purposes of review and evaluation in connection with the independent medical research referenced above. So you're going to waive your privacy rights in your medical records, and those medical records are going to be sent to these unnamed, unidentified, subject matter questionable researchers to use in helping them determine whether or not somebody may have been actually injured. Again, that does not sound to me like it's such a great benefit. You're waiving your privacy, and you should almost never do that, especially when you don't know who's going to get it. If you know your lawyer is going to get it, That's a different thing from you're giving it to somebody who might be researching cancer and they might be researching venereal disease. You just don't know. So the next one here, establishing and maintaining an interactive website for settlement class members to access the current medical information and guidance regarding the long-term health effects, if any, of use of the recalled devices, relevant medical information and guidance, and any valid and medically relevant results of the MAP research. So, obviously, they are saying here that there could be medically irrelevant results of the MAP research. That's the only way to read that paragraph. Again, I don't see that to be such a great idea, because if you've got medical questions about your long-term health and the long-term health effects of these devices, you need to see your own doctor, because he knows what your medical conditions are and how they may be affected by the use of that device. And then periodically posting on the settlement website relevant medical information and guidance, which will be provided in a user-friendly format for affected individuals who do not have a medical or scientific background, and disseminating the same to settlement class members who register to receive notifications. So essentially what they're saying here is we're going to dumb down medical information, put it on a website for you to look at. Again, if you need medical information, the person to rely on is your healthcare provider, and you shouldn't just accept that something put on a website, even by someone well-meaning, is necessarily 100% accurate. Gee, it doesn't sound to me like any class member here actually really gets anything. Oh wait, look here. No payments will be made to settlement class members under the settlement. Well, what a refreshing breath of fresh air and honesty. You're not getting anything from this settlement. Gosh, but okay, what do you give up by virtue of being in this class? Well, according to this notice, you agree to give up any claims for medical monitoring that were asserted or alleged or could have been asserted or alleged in the litigation, including the claims alleged and the relief sought in the medical monitoring complaint. Well, that is a pretty huge give up, because you have no idea as you read this notice, whether you are giving up claims that you don't even know about. They are alleged or could have been alleged. Well, many things could have been alleged. You could have alleged for damages in addition to medical monitoring. And you've not seen the complaint. It's clearly not provided with this notice, so you don't know what claims are in the complaint. So now, if you're going to opt in, or at least not opt out of this particular settlement, you have to go to the medical monitoring complaint to figure out what it is they alleged and what they could have alleged. I think there should probably be a requirement that they let you know what could have been alleged. But so far in the notice, that isn't there. Medical monitoring claims include all claims brought as a class action or on an aggregate or mass basis, meaning claims brought on or behalf of multiple individuals or on behalf of anyone in addition to yourself. Now, to be fair, it doesn't take you out of any personal claim you might have for medical monitoring. And that sounds like it might be a valuable claim. In other words, if you pursued Phillips for medical monitoring of your condition in your local district or circuit court, you could do so individually even if you were part of this settlement. But you'd likely never be able to do it because you'd need to hire experts and battle Phillips in court for that, and you'd likely have a hard time making the lawsuit economically feasible, since all you're talking about is the payment for certain medical tests that you don't even know which ones you need at this point. Here's the danger to you if you might have contracted cancer or some other disabling disease as a result of the use of these devices. Any facts that are determined in this medical monitoring action, of which you are a part, apparently whether you want to be or not, are going to be asserted against you on the basis of collateral estoppel in any other action that might be filed later on. So, for example, if certain diseases or disease categories are found as fact not to be related to exposure in these devices, something that at this point you could not know without going through all the discovery and all the pleadings and all of the orders in the case, you would be bound by that in your personal injury lawsuit that followed. And so you don't want to give up any valuable rights. In addition, the settlement states that 20% of the settlement fund will go to pay the lawyers, and the other $20 million will go to fund these benefits to the class. In essence, you are agreeing to pay a website designer, a settlement administrator, and whoever the researchers are, somewhere in the neighborhood of $15 to $20 million to do things that may or may not benefit you, or may benefit you, if at all, only in a very small amount. Essentially, you are giving away your right to file a medical monitoring class action on your own in your state for nothing. Essentially, you're getting absolutely nothing as a result of that. So now it's decision time. Now you have to decide if this is what you want to do. Is this what you want to be a part of this thing or not? Now that's your decision, and it's one that only you can make, and you should contact an attorney that you trust to determine if this is going to be of benefit to you. I am not offering legal advice, and nothing I say here is legal advice. But I am going to tell you what I, as a former consumer, a user of those devices, I can tell you what I'm going to do. First, I'm going to send an opt-out notice to both the court and the settlement administrator. I know in this piece of paper that it says I can't do that. It says I can't opt out. But Rule 23 of the Federal Rules of Civil Procedure says that I can. In addition, I'm going to file an objection to the settlement on the following 6 grounds. First of all, I'm going to allege that this is a collusive settlement. This settlement extinguishes claims but does not provide a dime of any tangible relief to any class member. Instead, it splits the money between lawyers and administrators and some unidentified future researchers. It provides you with a way to share your health information, which you obviously should never do, and it provides dumbed down medical information because lawyers think you don't have a doctor you could ask questions. It smacks of a settlement cobbled together by lawyers very friendly with Phillips. I'm saying the settlement is collusive. I am not saying that the lawyers are corrupt or anything like that. I'm just saying that this settlement looks to be a matter of collusion between people who want to get a quick payday and people who want to get off the hook on a claim. That's my thinking. Second, I'm going to file on denial of due process. I cannot be denied the right to opt out of litigation I don't want to be a part of. If you and I are in a car and we're hit by another car and I decide I want to sue, I can't make you join me in my lawsuit against the people who hit us. That's just not something that the law allows. The idea that I can be essentially kidnapped and held hostage against my will to be a part of a settlement I want no part of is a denial of my right to due process under the Constitution. So I'm going to allege that as a grounds. Then I'm going to say this is essentially an illusory settlement, that there is no tangible benefit to the class, that it is all smoke and mirrors, vape and vapor. Number 4, I'm going to allege that the attorney's fees, 20% of the settlement, are outrageous given the fact that the class is getting absolutely nothing. These folks are picking up what looks to be $5 million plus expenses, and they're not delivering anything. Number 5, the MAP benefits, the medical research or this medical advancement program, whatever it is, the MAP benefits as described are vague. They are too vague and too indefinite to permit any reasoned analysis of any value that would be derived from that. How does a class member know that the research will actually benefit anyone except the medical researchers? 6, the real parties in interest are not before the court. The only parties that benefit from this lawsuit, the settlement administrators, researchers, website designers, and attorneys, are not properly before the court as claimants. They are, in effect, misdirecting class benefits to non-parties as a settlement for the harm caused to parties in this lawsuit. I believe that turns the class action on its head. So that's what I'm going to do. You should consult with an attorney to determine what you should do. This is not legal advice. This is just me telling you what I'm going to do about a settlement I want no part of. Now, this last thing is very, very important. If you do not object or opt out, or I would say and opt out, do both by September 25th, 2024, then apparently if this settlement is approved, whether you wish to be bound or not, you will be bound. I believe the smartest play, as I said before, is to both opt out and, in the alternative, to object to the settlement under the terms that I laid out. If you have any questions about that, you really need to see your attorney. But if you decide to take action and opt out or object, make certain that you get it postmarked before September 25th. I would get it in the mail as soon as possible, within the next 15 days. And there are instructions in the little settlement notice that will give you instruction on how to make your objection known. You also have the option, if you want to appear at the hearing. And most of the time, what the court will do is hold something by Zoom so that you may appear. And I may very well do that. I don't know that I will, but I may very well do that. And if I do, then I obviously cannot broadcast that. I can't put it on YouTube because that would be against the court rules. But I will let you know how that goes if I determine that I need to do that. So that's what I have for you today. Thank you so much for watching. If you have any questions, like I said, about the lawsuit, you can certainly talk to your own attorney. On the other hand, if you have questions about the video or anything like that, you can feel free to drop them in the comments down below. I'd love to hear your comments about this. In my personal opinion, this is the kind of class action that makes people hate lawyers because it is just a money grab. At least that's the way it looks to me. That's my opinion. Again, I'm not accusing any lawyer of doing anything inappropriate. I'm just saying that the outward appearance of this is it looks like a money grab. So I would be interested in hearing your thoughts and takes on that. And of course, you can always, if you don't want to drop them in the comments down below, you can email me at the address above. If you have the opportunity today, do something kind for someone. My wife and I went to a little place called The Front Porch in Casita, Alabama today for lunch. And I had a Southern BLT, which is like a regular BLT, except that instead of tomatoes as those nice ripe red things that go on a BLT, these were fried green tomatoes. They put fried green tomatoes in the BLT. And I have to tell you, it was marvelous. At any rate, that's what I have for you. Thank you so much for being here. After you've done a kindness for somebody tomorrow, today, whenever, come on back and join me here at the beach and we'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.